Hello, my name is Ben Rhodes. I'm the Senior Vice President with CAMS. With us today, I have Steve Sellers, who's going to give us a talk about understanding and enforcing architectural restrictions. Before we get started, I want to congratulate Melva Sharp with Wrightsville Dunes. She was our Amex gift card winner after our last webinar this past month. We are in our 30th year, and so for the 30th year, we are celebrating that by drawing a $100 Amex gift card for every attendee. So you don't have to stay around to the end. We hope you do, but we will be drawing a name who will win that Amex gift card. Additionally, please, at the end of the webinar, if you can fill out the survey, let us know how we did, any other topics that you may be interested in hearing, and we certainly like hosting these and learning with every session that we do. If you have missed any of our sessions, they are available on our website, camsmgt.com, under the board members section, so you can view all of our past sessions. There's a lot of great content. We probably have close to 12, maybe 15 webinars that are posted, so you can certainly see those, look back on some of the historical information that we've done, and then obviously join us each month that we host these. We try and do them on the third Thursday of every month. So Q&A, we will be doing a Q&A. We're going to try and keep this session to 45 minutes of talking and then have a Q&A session for Steve to help answer as many questions as he possibly can. We are going to try and do a hard stop tonight at roughly 5:30. Steve has another commitment that he needs to get to, so we will try and end it as close to 5:30 as possible. So with that, Steve, I will turn it over to you.
All right, thank you, Ben. Let me try to share my screen here. You should hopefully be seeing my first slide now.
We do.
All right, very good. Thank you, Ben. Thanks to CAMS for allowing me to join you guys this afternoon. Good to be here, even if this is as close to actually being with people as we've been able to get over the past couple of years. It'd be nice to do these in person again soon. I am Steve Sellers. I'm one of the partners here at Sellers, Ayers, Dortch Lyons. We represent hundreds of HOAs in North and South Carolina. There are 3 of us here that are essentially dedicated to that nearly 100% of the time. I'm one of those. I want to have an opportunity today to cover some basics but important points as it relates to architectural review and control. I am going to try and move through my presentation in about 45 minutes. I will, if I start to get way beyond that, then hop on the screen and stop me. I do want to have a chance to answer questions for you all. Let's talk a little bit though about where we're going to go in the next 45 minutes together. First thing we need to talk about is understanding the sources of your architectural review and control authority. Where does that authority come from? And what are some special considerations that you need to give as you're looking at your own governing documents, for example, to see what your board or your architectural review committee is and is not authorized to do. We'll move on from that and talk about practically some of the best and some of the worst things that we see boards and committees do as they exercise that authority that they have. We'll transition from that to talking about enforcement options that are available to you, so that hopefully by the end of that part of the talk, you'll understand at least what the options are. Obviously, which one you select and how you proceed with it is going to be fact-specific, case-by-case basis, but you'll have at least a roadmap of what the enforcement options are. And I'm also going to try and give you some practical examples of how those enforcement options can play out in 3 very common scenarios that we see with our clients. And then finally, before we transition to questions for hopefully at least 15 minutes, 20 minutes or so, we're going to talk about just some special considerations and some tripwires and hazards that we see our clients sometimes unwittingly fall into, hopefully so you can avoid those. So on the issue of authority and where it comes from, I know we've got folks here from both North and South Carolina. The reality is that very little of what we're going to talk about today, with the exception of one issue related to architectural guidelines that I'll mention later on, and then the enforcement side of things. Very little of this is driven by state law, by any sort of statute. It is driven by what your particular governing documents say. In North Carolina, it's generally going to be a declaration of covenants, conditions, and restrictions. In South Carolina, that document is sometimes called a declaration, sometimes called a master deed. In either case, it's the recorded restrictions that govern your community and the properties there. That's where we're going to be looking. The key element of this is, what do your particular governing documents say? It would be a mistake to think that your governing documents are just the same as the community next door. Or you may know someone who is on a board or a committee in a community across town, and they tell you what they do, and it would be a mistake for you to think that that automatically applies to you, or that your governing documents are the same. They are almost surely not. Some of the things, and I'm going to give you an example here in the next slide of a provision, and we'll sort of walk through some of these key aspects. But the things that I want to have your antenna up for: number one, who is authorized to make these architectural decisions? Is it the board of directors acting as the board? Is it a committee that's appointed by the board? Are there, if it's decisions that are primarily made by an architectural committee, are there appeal rights to a board of directors? It's not necessarily true that there will be. In fact, that's somewhat rare. Beyond the who of this, who makes the decisions, is the what. What sort of changes to the property are covered by our particular form of architectural control? Is it limited to man-made improvements only, structures that are built? Does it cover landscaping? If somebody wants to change the type of grass that they have planted on their lot, is that an architectural matter? It may be, or it may not be. Are there limits on what the reviewer, whether it's the board or a committee, can consider? It is, I would say, more often than not, the limits that apply to what a reviewer can consider are fairly broad, but that is not always the case. You may have a situation where your particular set of governing documents authorizes the board or the committee to essentially evaluate an application solely based on its compliance with the recorded restrictions. Again, that's rare, relatively rare, but it can happen. And we just want to emphasize the fact that if you were on a board or on a committee that is reviewing architectural matters, you owe it to yourself and to your community to read through what your document actually says and see what's covered and what's not. Before we get into architectural guidelines, I'm going to skip to this slide. And this is just the first part of a provision that actually became an issue in a case that I handled personally. The all caps portion of that provision talks about what this particular community was authorized to deal with in terms of architectural review and control. Now, I want you to read that. I'll read it as well. But no building, pool, fence, wall, solar panel, antenna, dish, deck, patio, room addition, exercise play equipment, or other structure or improvement of any nature shall be erected, constructed, demolished, or altered, etc. One of the things that became critically important in the case that I was involved in that hinged on this language here was the fact that that association had gotten itself into a long history of taking this language and applying it to proposed installations that were entirely composed of landscaping, not a single man-made component whatsoever. Planting trees, grass, plants, things of that nature. And it actually blew up into a lawsuit. And one of the issues that turned that lawsuit against this particular community was the fact that this language only authorized architectural review and control over man-made structures and things like solar panels, decks, patios, things that you construct. You can even follow the language down a little bit further. Talks about the plans and specifications showing, or excuse me, the sentence before that says none of these things, all of which are man-made, shall be erected, constructed, demolished, or altered. The determination in that case is that those verbs, erected, constructed, demolished, and altered, taken together with the preceding words in the sentence that were all man-made structures, did not reach landscaping. And that association ended up having to pay a settlement. They were understandably shocked when they realized what they did not have and what they thought they did have in terms of architectural authority. If we continue reading down here, this particular community has a board, obviously, that is authorized to make these decisions, or an architectural control committee. So it's an either or. Your provisions may provide that the board solely has authority to handle architectural review and control, or that a committee solely has the authority to do so. Under this particular language, it's an either or. The board can do it, or the board can appoint a committee to do it. Now, what does this language tell us if we do choose to appoint a committee? What does that committee look like? It must consist of not less than 3 nor more than 5 people who have been appointed by the board. Not only does the board have to affirmatively appoint those people with some sort of formality that's memorialized in board meeting minutes or something like that, the committee has to be a certain size, not less than 3 nor more than 5. There's actually a North Carolina case that has just come out very recently. We'll touch on this a little bit more in a few minutes. The case came out where the issue was a committee with a very similar parameter, not less than 3 nor more than 5, had in practice allowed a single person, just a single, very interested, very aggressive person on that committee to make all the decisions. It didn't act as a committee of between 3 and 5. It acted as essentially a committee of 1. And in that instance, those architectural decisions that were made were essentially thrown out, because the governing documents for that community specifically required the committee to act, specifically required a committee of between 3 and 5, and that had not been followed. Your documents may have very similar requirements in place, and if they do, you need to know what those are and make sure that you're compliant with them. We'll move on from here just in the interest of time, but I thought it was helpful to look at an actual provision that can have some hidden hazards in it, whether it's exceeding your authority and treating landscaping applications under language like this, or, as we see, frankly, far too often, committees that don't really act like committees. They act like single individuals making all the decisions. The architectural and design guidelines can be sort of I think, a tricky concept for folks to understand. First off, in North Carolina, these are usually not recorded. In South Carolina, because of some not so new legislation now, they do have to be recorded. You need to understand not only what these guidelines are and the function that they serve, but who is authorized to adopt these guidelines and to change them. Typically, if you have a board or a committee that's authorized, just like the example that we just looked at, it's very often going to be the board that has ultimate control over what goes into the guidelines. If, on the other hand, you have a committee that holds all of the architectural review and control authority, the board appoints those members to the committee, but then it's very likely that committee that has almost complete discretion over what the guidelines say. Now, there's a little asterisk next to those statements that I just made, because your governing documents will control what happens in your community. But typically, the arrangement that I described that's pretty much what we see. You need to know what you have, because if you have a set of documents that authorizes an architectural committee to be changing the guidelines, and in practice you have a board of directors that's doing that, that's going to create a problem for you. And it's an easy problem to avoid if you will take the time to read what your documents say. As far as what the guidelines do, what they are intended to do, they are almost always a guide for the reviewer and for owners. And when I use reviewer through the course of this presentation, I'm referring to the board or a committee, as the case may be in your particular community. Um, these are not recorded restrictions. I know up in South Carolina, I mentioned a moment ago that they have to be recorded. That doesn't necessarily make these recorded restrictions like the provisions in your declaration or your master deed. Your governing documents are going to tell you what your guidelines do and what they don't do, or they should. There are declarations out there that are poorly written and don't clarify that. But more often than not, what we find is that there is a clear statement of what the guidelines do, and they are almost always a guide that indicates what is likely to be approved. The reason that this becomes important in a very practical way is it's not uncommon for us to have a client who has a violation or what they think is a violation. And when I start asking them questions about what this person has done or what provision in the governing documents they have violated, I often am pointed to some provision in the guidelines. The problem with that is that in 95% of the cases, the guidelines themselves are not enforceable standing on their own. You wouldn't point to a provision in your guidelines document and say, you violated this and now we're going to exercise our authority to fine you or something like that. What you would probably do is say, for example, if somebody had submitted an application for some sort of improvement to build a doghouse. They got approval to do that and proceeded with the approved application. But what they ultimately constructed wasn't consistent with some provision in the guidelines. The knee-jerk reaction from a lot of clients is we're going to cite them for a violation of that guideline. And that's the wrong thing to do. When it comes to our office and comes to my desk or one of my colleagues' desks, what we're going to tell you is don't cite the guidelines, cite the provision in the declaration itself, which says that you can't essentially build this improvement, in our example, a doghouse, without approval, and whatever you build must be consistent with the approval that you're given. I'm paraphrasing there, but the point is you want to be avoiding the tendency to try and use the guidelines for a purpose that they don't serve. They truly are a guide that is intended to allow me as an owner to open up, look at what the requirements are going to be for a doghouse and make sure that the application that I put together meets those guidelines, because I have a better idea that it's going to be approved if I do that. Not necessarily a guarantee that it would be approved, but it's helpful for me to essentially have a checklist as an owner to know what's likely to be met with approval and what's not. On the reviewer side, you have turnover on boards, turnover amongst committees from year to year. And the guidelines are helpful in the sense that they provide some consistency as there is that turnover, so that you don't have a reviewer, whether it's a board or a committee, 5 years ago that's making dramatically different changes or dramatically different decisions than what we intend to do today. The guidelines can certainly evolve over time and so forth, but they are there to try and allow for some consistency over a number of years as there is turnover on the reviewer. Do not confuse your architectural guidelines with rules and regulations that your association may be authorized to adopt. Two examples I have listed here are ones that are, I think, they can be confusing for folks, and clearly they are, because it does come across my desk more often than I would like. But if you parse out the difference between a guideline that is going to tell me, for example, what my trash can enclosure has to look like, from a rule that says, for example, I can't leave my trash can out by the road except on collection days. It's very common for me to look at a set of guidelines that have been adopted, look under trash cans, and see sort of a blending of structural matters that relate to enclosures that are designed to obscure trash cans from view, mixed in with rules and regulations about what people can and can't do with their trash. Same thing with basketball goals. The guidelines would be an appropriate place to have expectations about where a basketball goal is going to be permitted to be installed, what it has to look like, what the components need to look like, et cetera, things that have to do with the structure itself. It would not be an appropriate place to have a prohibition against playing in the street, for example. That's conduct. That has nothing to do with structure. That's conduct. And if you want to pass a rule that says you can't use your basketball goal in such a manner that you're playing in the street, we need to look at whether that's something you can adopt through rules and regulations, not something that you can slide into your guidelines and then try and enforce later. Hopefully that distinction is clear at this point. We sure see it a lot. My encouragement to you, if you're listening to this right now, would be to go through what you're calling your guidelines and start highlighting or circling everything that starts to sound like it's talking about conduct and what people can and can't do on their property. It's very, very likely that those items that you're circling and highlighting should probably be pulled out of your guidelines and dropped into an enforceable rules and regulations document, which is its own separate presentation on what your authority is to adopt rules and so forth. But for our purposes today, I think it would be helpful to go through and start to diagnose whether your guidelines document is maybe impermissibly blended with rules and regulations that you would want to enforce. Moving on to some practical applications, best and worst practices. We'll talk about some of the best practices first. Do use your guidelines to establish procedural requirements for submissions. It's an appropriate place in most instances to specify what the plans need to include. You may have a set of governing documents that just says that the plans and specifications have to be submitted to the committee or to the board. Well, great. What does the plans and specifications consist of? The guidelines is a great place to put some more flesh on those bones, so that people understand when I'm putting together my submission and asking for approval, this is what I've got to include, whether it's a survey or marketing materials for a exterior shed that I want to put on my property. That's sort of one where you would just go buy it and essentially have it dropped onto the lot. What is it gonna? Do we need pictures? The sky's really the limit, unless there are limits imposed by your declaration. But the point is, you want to use your guidelines to set the standards that people will then know they need to follow, so that you're not constantly having to follow up with people and say, we require this, you haven't provided it, we can't consider your application until it's here. You can shortcut some of that by making it very clear in your guidelines what people have to submit. And then we'll talk about this in a minute as well. Once those are set, don't deviate from it. I won't talk about that too much here because it will become relevant a little later. But once you have those procedures set and you've told people this is what an acceptable application looks like, you need to hold yourself to that. Don't get lax with it just because it may be easier in a given case to relax some of those requirements. As a committee or a board considering architectural matters, do meet regularly to discuss the submissions that you've got. You've got some I think some resources that people don't always take advantage of. Sometimes we find our clients feel like they have to all be in the same room together to have a meeting, whether it's a board or a committee. We think there's some flexibility there for you to not necessarily have to all be in a room together, to handle these matters in a conference call or a video conference like we're using right now. The point is, do regularly schedule meetings where you're going to discuss these submissions. Now, how frequent those need to be, how long they need to be, obviously that's going to be dependent on your particular community. Some of our clients don't have more than a couple of architectural applications every year, if that many. Others, it's a huge part of what they do on a day-to-day, week-to-week, month-to-month basis. The procedures that those associations follow are going to vary dramatically. But the point being, make it a priority to get together and actually operate as a board or as a committee in considering these submissions, making your decisions, coming up with questions or clarifications that you require. When necessary, do seek outside help, whether that's from your quality property managers that you have, whether that's from an attorney, whether it's our office or somebody else. If you have a question and you don't know how to apply a certain restriction that you're looking at as you are evaluating an application, or you have a concern about whether, let's look at it this way. Very often when a client comes to me with a question about how should we rule on this architectural application or that one, they're very often trying to draw very fine lines to distinguish a past decision that they've made from the decision that's right in front of them. That can be difficult to do. And we understand, and frankly, the law understands that you are volunteers, whether you're on a board or you're on a committee. Use the resources that are there to help you. Above all else, don't let the need for help or questions, difficult questions about a given application sort of paralyze you into not acting at all, and just freezing. If you need help, need assistance, that's what your professional property management assistance or legal assistance, or even if you need architectural assistance, that's what it's there for. Use those resources. Do issue clear and thorough responses. This is a pet peeve of mine, and I know a lot of the folks here in my office. We will see communications, whether it's in the form of an email or even on a formal approval document, for example, where we're just not using complete sentences, or it's fragments of a thought versus taking the time to actually spell out what we're saying in a way that cannot be misunderstood. The third little bullet point there is one that my father, from the time that I was very, very young, told me, don't speak so that you can be understood. Speak so that you cannot be misunderstood. And I think if you apply that to the way that we interact with owners on architectural matters, go over and above what you think is necessary in order to be clear about what you're requiring. I can't think of a better example of a time when that is absolutely critical than when we have an association that wants to issue what they sometimes call a conditional approval. It's basically saying you're approved, but whatever comes after that but needs to be very, very, very clear and explicit, because you have given this person in that scenario an approval to move forward with conditions that if they're not clear or there's any ambiguity at all, that is going to come back to bite you. I have in my note here that conditional approvals like that are discouraged. There are definitely pros and cons to using them. There's some efficiency there, probably just in the interest of getting a decision out and published to the owner. However, then this is anecdotal, just my own experience. I know that the architectural issues that make their way to my desk as a full-blown legal matter that requires legal assistance very, very, very often include an aspect of a conditional approval that was not clear and was either misunderstood by the owner, maybe in good faith, or was included some sort of an ambiguity that the owner intentionally exploited, but still left us in a very difficult situation. So just the takeaway point there is just to make sure that when we are going down on paper with expectations about what is and is not approved, we need to be clear, need to be explicit. We need to make sure that we're speaking and writing so that we cannot possibly be misunderstood. When you do issue a denial, explain the basis for the denial. We'll talk about this a little bit more in a moment, but there's nothing more frustrating to a homeowner than just getting a flat denial that essentially says, no, try again. If you have a reason for denying the application, tell them what it is. It may be something that they can address and fix in a later submission, and maybe it won't be. But either way, you go a long way towards just managing the situation with the owner that you're dealing with by engaging with them and telling them why you've denied their project. Do pre-approve whatever you can, but do so carefully. I'm thinking, when I say that, what I mean is potentially in your guidelines, issuing certain parameters that a person can meet such that they don't have to apply for a given improvement before they move forward with it. One example that I've seen very recently actually had to do with flags. There were certain flags that the association was prepared to essentially pre-approve, not require people to submit an application for. And in so doing, they had their guidelines section on flags say, if you check all these boxes in terms of size, number, location, etc., you don't have to ask us for permission. I think that makes a lot of sense from an efficiency standpoint where you can do that. But you have to bear in mind, again, that if you're laying out your expectations for what's pre-approved and you leave any room for ambiguity or debate as far as what's allowed and what's not, you're creating problems for yourself in the future. So you take something that could have been a huge time saver and a very positive move in terms of efficiency, and you've just created issues where you got to call somebody like me. So do pre-approve what you can in the interest of efficiency, but be very intentional about how you do that and be obviously extremely clear about what you do. We'll move through the don'ts quickly. We already touched on these sort of tangentially. Don't deviate from your requirements for submissions. If you require a submission to include A, B, C, and D, don't deviate from that. Don't take the shortcut of texting with the owner and trying to modify an application that way. That's going to create problems and confusion. Where again, you'll go from a situation that might have been managed without legal assistance to one where you've got to call me. Don't relinquish decision making to a subset of a committee. If you're supposed to have a committee of between 3 and 5, operate as a committee between 3 and 5. Don't allow Bill, who just is real gung-ho about architectural matters, to make all the decisions. You put every decision that you make at risk if you do that. Don't issue flat denials when a submission could be revised. That's again, don't make them guess. The last bullet point down there. If you have a denial that you've got to issue, you got a good reason for doing it, tell them what it is, give them an opportunity to resubmit if it's something that they can fix. Finally, don't issue just arbitrary denials. One example, we never approve pools, for example. You can't possibly put a pool in front of us that we would approve. I think that's arbitrary. It's very likely, not in 100% of the cases, but more often than not, it's very likely that somebody could propose a pool installation that could be met with approval. The obvious caveat to that is if you've got a restriction in your governing documents that says no pools, then that example doesn't work. But the point is have a good reason for why you don't allow what you're saying you don't allow. And very often just flat categorical denials, we don't allow pools, it's not going to work. It's going to create problems. Best practices with respect to approvals. When you can, refer to a specific completed submission by reference to some sort of identifying information, either the date of the submission or an application number. I know not everyone has application numbers. The point that we're trying to drive home here is when we issue an approval, we want it to be absolutely clear what exactly we are approving. Got an example there, just a way that you might phrase what I think is a very clear reference to an architectural application that's been amended a couple of times in this example. It doesn't have to sound like that. Those aren't magic words, but it's an example to show you how we can very clearly show how an application has been approved, even when it's been originally submitted and then maybe amended a couple of times with some dialogue with the owner. When it's possible to do so, attach a copy of the submissions to the approval document itself. If you've got an approval, a submission that's been given to you and marked up and things have been changed, make sure that those changes are clear, that there's no ambiguity, and then attach that to the approval. What we want to create is a clear and concise record that all parties involved, association and owner, can go to and see the approval, and then ideally, whether it's in paper or electronic form, see exactly what that approval corresponds to, so that there can't be any room for debate on what was approved or what wasn't approved. Enforcement options. This is where we do get into some statutory law that we need to be aware of. You've got 3 general approaches to enforcement. I know I'm getting short on my time here, so I'll start picking up the pace a little bit. Those three options that you have are administrative, self-help, and judicial. When I talk about administrative enforcement, what I mean generally is things like hearings and fines, the suspension of privileges, to the extent that fines go unpaid, foreclosure of a lien for unpaid fines, et cetera. Basically, internal things that we do as an association based on the authority that we either have under statutory law or under the governing documents for our community. In North Carolina, you're going to look at your governing documents, and depending on the type of community that you're in, either Chapter 47F or 47C. F for planned communities, townhomes, and detached single family, and then 47C for condominiums. Both of those statutes have sort of baseline due process requirements for how hearings and fines and things like that are handled. That's something that your manager is familiar with. It's something that obviously we're familiar with. And to the extent that you have questions about what you can and can't do in North Carolina, ask them. If necessary, ask us. We're going to be looking at your governing documents and those two statutes to tell you what you can and can't do. In South Carolina, it's just based on your governing documents. You will potentially have fining authority. Maybe you don't. I don't know without looking at your governing documents. We don't have any statutes to fall back on there. So if your governing documents as they're written today don't include fining authority, don't try and levy fines. You will get sued, and it will become very expensive. In addition to administrative, you got self-help remedies. This is where our governing documents sometimes allow us to go onto a person's privately held property and correct the violation. We don't, our firm doesn't like these options. And I say that because if you are wrong in your conclusion about whether this is an actionable violation, and you go on to somebody's property and you try to remove something or change it and destroy it, that's going to be a disaster if you're wrong. That's why that last bullet point there says, when in doubt, get court backing first. Basically pursue the third option, the judicial option, which means a lawsuit going in front of a judge, and get a judge to say, yes, you, the association, are authorized to do A, B, C, and D. And if part of A, B, C, and D is to go onto the property and return it to its original condition, now we haven't just launched out into that on our own. We've got a judge behind us saying you're authorized to do this. The judicial option can also take some different forms. There are going to be three sequential steps for most lawsuits involving architectural matters. First is going to be to get a TRO, which is a temporary restraining order that's very, very short in time, where the judge will tell somebody to do or refrain from doing something, pending the issuance of the next step, which is preliminary injunction. That's usually just a pause button that maintains the status quo while a main lawsuit is going on. And then the purpose of the main lawsuit is to get what's called a permanent injunction, which is it's an enforceable court order telling somebody to do something or to refrain from doing something. In situations involving architectural review and control, usually the permanent injunction that we're going for is either a court order that they have to tear something down that they built without approval, or that they built in a way that was inconsistent with an approval that they were given. But that's essentially what you're going to be going for. You could also have that blended together with the enforcement of fines if you had taken administrative steps first. Those didn't work, and then you moved on to judicial. You may have fines that have accrued, and part of your lawsuit now is not just getting the enforceable court order, but it's asking a judge to enforce those fines that you've already levied. So there can be some blending of these three options. Generally, which one you select between administrative and judicial is going to have a lot to do with the severity of the violation. And obviously cost considerations. I mean, most of our clients, when they start looking at these options, they go the administrative route just because they control their own destiny and they don't have to pay a lawyer at every turn to pursue it like they would a lawsuit. So judicial is an option, usually only reserved for the most egregious of violations. Extremely rare in our in our experience, but it's available. Some practical applications of those enforcement strategies. These three situations are ones that come up pretty often, where you have an approved application and a non-conforming construction thereafter. Maybe you go the administrative route and issue fines after following the proper procedures, obviously, plus a reasonable opportunity to bring whatever that non-conforming construction was into compliance with the application that you approved. You might also look at whether, instead of requiring them to change what they built, is this a situation where a solution might be to find an effective way to conceal what they did from view, to screen it in some way. That's an option that's available as well. Second scenario, you have an acceptable construction, but they didn't apply. They didn't ask first. So they've got a procedural, substantively they're fine. The construction is something that we would have approved if they asked, but they didn't ask. One option there is to go through the administrative process and issue a fine for failure to properly submit the request, and have them do that after the fact. That's often the most streamlined way to respond when what they did is substantively acceptable. It is, I think what we're trying to do in a situation like that is have there be some meaningful consequence in the form of a fine for the failure to follow the proper procedure. Because what we don't want is for it to get out in the community that what they say about those requirements that you have to ask first isn't really the case. And if you just do it, they'll let you get away with it, basically. So we want to strike that balance between having some consequence for the procedural violation, but also understanding that what they did is, as far as its location, the way that it looks, the end result is fine. Third scenario, no application, unacceptable construction, the worst situation. This may be one where you try fines, maybe those fines don't work. If you've got somebody who is just flaunting any requirements that you've got in your governing documents, they're not asking, they're building stuff that goes against restrictions, that may be a person that fines are not going to be sufficient to address. And if that's the case, you're either going to decide that it's not worth the fight and you're going to give up on that, or you're going to try and lean and foreclose for those unpaid fines, or try to get in front of a judge to get a court order. Fortunately, the last one doesn't occur all that much. I'm not to say it doesn't, and I know there are people on the call who have seen it, but it's usually some version of the first two. And those are just some ideas on how you might approach those from an enforcement standpoint. In the last few minutes that I've got here before we transition to your questions, just some special considerations that I want to put on your radar. And this first one is a big one. And I do a presentation on the Fair Housing Act and reasonable accommodations and modifications under the Fair Housing Act. And that's its own hour-plus long presentation. What you need to understand, though, is that there may be circumstances where a person with a disability in your community is entitled to a modification of their property that you wouldn't allow anybody else. And they get that because they have a disability that the law recognizes, and they have a disability-related need for that modification. Now, as I said, there's a whole lot that goes into that analysis. And if you get a situation where somebody is saying, I need X, and the reason I need it is to accommodate my disability or accommodate my condition, you need to be reaching out at a minimum to your property manager and probably to legal help as well, to understand what you can and can't ask for, what you must and must not do in response to that. The fair housing issues related to reasonable modifications and reasonable accommodations, which is basically a deviation from a recorded restriction or a rule, are very, very common. And they run the gambit from matters that have absolutely nothing to do with architecture, like support animals, to ones that are very, very much involved in what we're talking about right now, which is I need this modification to the physical premises that I live in to accommodate my disability. And I recognize that nobody else who doesn't have this disability is going to be entitled to this, but I am, and federal law gives me that. Need to be careful. If you hear anybody making noise about disability and asking for an exception, red flags and buzzers need to be going off everywhere. to ask for some help. Be aware that you may have a provision in your declaration that provides for a response from the board or from the committee within a certain period of time. Usually it's 30 days when you have one of these. If you have to approve or deny within 30 days, or the application is approved by default, don't miss that deadline and try and articulate some good reason for why you missed it. Those are hard deadlines. They're the equivalent of a statute of limitations in a lawsuit. If somebody gives us a submission that's complete, and again, I want to circle back, this is a reason why in your guidelines, it makes a whole lot of sense to have very specific requirements for what is a complete submission. Because then we can argue if somebody submitted something that is missing one of those key components, they haven't made a complete submission yet, and our 30-day period doesn't start to run against us. Just some strategic options that are available there. But read your documents and see if you've got one of these deadlines. Not all communities have them, but a lot do. And it's come up and hurt a couple of clients who just were unaware that it was there. I'll skip down because I do want to wrap up and get your questions. We're already at 5:18 now. The issue of variances comes up a lot. Is the committee or the board authorized to issue a variance in what we allow to be built? That's not some authority that you just have because you're a board or a committee. Your governing documents either authorize you to grant variances from restrictions in your governing documents, or it doesn't. And if it doesn't, then you don't have that authority and shouldn't try to exercise it. Again, these are just some concepts that I'm not trying to fully flesh out because we don't have near the time to do it. But I want to put these on your radar so when you're sitting around the table looking at an application and one of these pops up, a request for a variance, a request for some disability related accommodation, you need to have that red flag go up and realize that you've got a potential hazard in front of you that we need to figure out a way through for you. That is all I have time for. We'll go ahead and transition to questions. Ben, I think you've probably been watching the Q&A.
Got a couple of questions. So one thing I wanted you to clarify before we started the questions.
Yep.
So we talked a little bit about rules versus architectural restrictions.
Yep.
And I guess architectural restrictions on lots versus rules on common property. And can you maybe give a little more information on that?
Yeah, I can try and do that. And you tell me if I'm going in the right direction. So I think what Ben is getting at is the fact that your association has a set of governing documents that's going to include recorded restrictions in the form of your CCRs or your master deed. Those are hard and fast restrictions that apply to every lot or every unit in your community. On top of that, you may have the authority, and probably do have the authority, to make at least some rules and regulations. Those rules and regulations, though, may be limited to just what people do on common area. Or maybe we have the authority, based on how our governing documents are written, to make rules, usually at the board level. We're not going to the membership as a whole to get these things approved in most instances. A lot of times the board will have the authority to issue rules that's maybe not limited to just the common area. It's what people can do on their lots. And understanding the extent of your rulemaking authority is critically important for a board when you're looking at making rules governing what people can and can't do in your neighborhood. If you're a community where the board is only authorized to make rules that address what people do on the common area, and then you try and issue and enforce a rule about the kind of flag that you can hang on your property, that rule is not going to be enforceable. Now, beyond restrictions, beyond rules and regulations, we've got this separate document, the architectural guidelines that we talked about today. And that's exactly what it sounds like. It's a guide to help the reviewer and the owner navigate the application process. I can't think of a scenario where I felt comfortable telling a client, proceed with a violation, trying to find somebody, and base that violation on just a provision in your architectural guidelines. I can't think of a single time when I've done that. So I think what Ben is getting at is just the difference between those three documents. Ben, if I've missed the question, then try again.
That's great, and just a little clarification between the two. So, first question: Our community is supposed to have a committee of 3 to 5 members of the architectural committee. However, the developer has only one appointed person who makes decisions and maintains the records. Decisions have not always been consistent. The homeowners will be voting for their first board of directors, and the original person could still be the ARC because the developer still owns a lot. What recourse do we have, and can you offer any advice on that topic?
All right. So that's a very complicated issue. What I'm hearing in that scenario is we've got a set of governing documents that establish, presumably even during this period of declarant control, the fact that there's supposed to be an architectural committee, and that committee is supposed to consist of 3 to 5 people, but maybe that the developer has the right to pick who those people are. Ben, do you think that I'm on target so far with what the question is?
You are.
Okay. And it sounds further like the developer is not following that. That becomes a very tricky situation because you're looking at whether there are any grounds legally and practically whether it's even possible to hold the developer's feet to the fire to follow their own documents. I mean, that sort of a situation is one where more often than not, the association is going to limp along as best it can until the point of transfer or turnover, which is the point at which the developer stops having that authority and we elect a board that consists of homeowners that are elected at an annual meeting or something like that. And then those individuals who have been elected by the membership then appoint the committee members, and then we do what we can to follow the governing documents. Your developer may be wrong in what they're doing. The fact that, or the question of whether that's something that you have as an association, adequate means to address is entirely different. And that's a situation where you probably do want to reach out for some help to navigate that.
So I'll say one thing that we didn't do is the disclaimer on, Steve is offering a lot of information without specific governing documents, and every set of documents is a little different. So if there are additional questions as a follow-up, please make sure you get with your HOA attorney.
Yeah, I appreciate Ben having my back on that. What I'm trying as best I can to address these general questions, but that you can't take anything that I'm telling you here and tell your fellow board members or your members of the community at large that you have a legal opinion. You don't. You need to get that from your own lawyer who has the benefit of your governing documents up front.
And the other thing to mention with declarant situations is there's generally multiple people within the declarant's office or developer's office that are also on the board. There's just maybe one person that's acting as the figurehead. So it will vary from company to company greatly. So I don't want to.
Absolutely.
But so next question: If a homeowner in a condo setting claims that exterior changes were approved by an ARB, and the association has no records of those, whose responsibility is it to prove that there was an approval?
Well, I think that's going to depend on how long ago was it. You said this is a condominium. That triggers in my mind whether we're looking at perhaps an unauthorized change to common elements, things that aren't part of the person's condominium unit. Whenever that's become an issue in the past, or someone has wanted to make an exterior change to a condominium, they're very often talking about making changes into property that they don't own. It's not part of their unit. And when we've given approval to do that or counseled a client on how they can give approval to do that, we've always tried to have separate agreements in place about things like maintenance and so forth to memorialize things and avoid the situation that this question implicates, which is there's a lack of records. If you've got an improvement that's been in place for years, you're not going to have any luck going in front of a judge and getting them to take that thing down. That's a practical reality of it. And I suspect that that's the situation that exists behind this question.
So this question, I'm going to paraphrase the question, but I believe it has to do with applications. Let's say there's no application, but the structure has been built and it meets compliance.
Okay.
How should we handle those types of issues where the item, let's say a fence was installed correctly, but there's no application on file?
Right. So I'm going to go back because I think what we're looking at here is point number 2 over here, where we have an acceptable construction but no application and approval. How do we handle that? I think you use the administrative enforcement options that you have to have that person suffer some consequence for the procedural failure. They're found in violation. They constructed something without prior approval. They get a violation and a fine for that. But we give them an opportunity to submit a proper application after the fact and basically backfill the documentation. I think that's the most efficient way to handle that situation.
Okay, this may be a fairly long question.
Okay.
I may come back to that one. Our 20-year-old poorly written CCRs
Good start.
include the following. ARC guidelines are enforceable as rules and regulations. How do we reconcile this statement?
And you follow what your governing documents say. If your governing documents essentially give you super guidelines that are more than what I've said is typically the case, you follow what's in your declaration. And if your guidelines are enforceable as rules and regulations, then you talk to your attorney and decide if you're comfortable proceeding on that basis. But that's a unique statement, and I think you've got to acknowledge that that's unique and treat it as such.
Okay, if you grant an exception for a person with a disability and that person sells their house, can you force those exceptions to now be removed?
That is actually a question that is so factually dependent that I cannot begin to answer it here. You're talking about a situation where you have a reasonable modification to the premises. So we physically change the premises, usually in some aspect of I can't even go there. We see this a lot when you've got a condominium where the common elements are owned not by the association, not the entity itself, but by all of the owners collectively. And somebody needs to install a handrail or something like that. In that situation, that handrail, once it's up, stays up. You can't require them as a condition of getting the modification to promise to take it down before they leave or something like that. I think that's about all I can do with that one without having a lot more facts in front of me.
Okay. Can the ARC guidelines be part of rules and regulations, or should they always be two different documents?
Physically, if we're talking about whether we've got a single document with two parts that are separated, I mean, I don't really care if it's one document as long as it's clear that these are rules and regulations and these over here on pages 15 through 20, whatever, are our guidelines. I think you could have a scenario where you've got a single document just for the sake of convenience, but don't blend your guidelines intermingled with rules and regulations. That's going to create confusion, in my opinion.
So how involved should the ARC be in inspecting the work after it has been completed? And should they venture onto someone's property to justify that the work was done as designed?
Whether you have the practical ability to do that or not is probably going to depend on what easement rights are reserved to your board and to the committee for that purpose in your governing documents. You don't necessarily have the right, just as a matter of law, to go in and confirm that what was constructed was actually constructed appropriately or as approved. However, it's not uncommon in well-written declarations to have a specific statement that the reviewing entity, whether it's the board or the committee, has the specific easement right to go onto somebody's property to evaluate compliance. I think how you exercise that authority, assuming you have it, really depends on how critical this particular project or improvement is. If it's a situation where it's a relatively minor change, you might make a decision that we're not going to exercise our authority to go and check it out. If it's something that's not visible readily, unless you go deep into the owner's property, you might decide just to let it go at the approval. If it's a major project, I mean, I can think of, pool installations or things like that that are visible from roadways or public areas. Maybe those facts would lead you towards wanting to go onto the property and make sure that what they actually installed is what we approved. It's a judgment call, and it's going to be based at the outset on whether you have the authority to do it at all.
So if you issue variances on one home, do you have to offer the same variances on other homes that are asking for a similar structure?
Let's start out with clarifying some terminology. When I use the word variance, what I mean is an exception to the restriction in the sense that if the association allows this exception, another owner would no longer be able to enforce that restriction against the person who got the variance. I know that may be a little confusing and it may be a little bit too far into the legal weeds, but the point being, a variance is something that's even more than just an exception. A variance basically is where we say, we know there's this restriction over here that would prohibit this, but we have the authority under our governing documents to allow a variance such that you do not have to comply with this anymore. And the reason that that is significant is that in the concept of a planned community or a condominium, everybody who takes a deed that's subject to that declaration that we're all under this umbrella, any one of those owners could take enforcement action legally, file a lawsuit against any other owner that's violating the governing documents. Does that happen often? No, it does not happen often, but it could. And the significance of a variance is that it cuts off that owner's ability to take enforcement action on their own. That's an important thing to understand. Now, I think what the question is really getting at is the degree to which we have to be consistent from one application to the next, which may involve things like variances. Obviously, if you're going to make a decision over here on the right hand that's different than a decision we've made in the past over here on the left, we need to be able to articulate a good faith basis for why this factual situation over here is different from this one over here. If you cannot expect to just make an exception for homeowner A and deny that same exception to homeowner B under a similar set of facts and not have a problem, you're going to be accused of selective enforcement, you're going to be accused of discrimination, etc. The key is if we're making a different decision, one application to the next, we need to have a good faith factual basis for saying these two folks are not actually similarly situated. The topography of this lot is completely different. The arrangement of this lot as a corner lot is completely different than this one over here that's not a corner lot. It's got structures on both sides of it. All sorts of practical things that can go into play and help us justify making what appears on the surface to be inconsistent decisions and show that there's actually a very good reason for that. That really highlights, I think, the importance of, as a committee or as a board, making a written record of the reasons that you're making the decisions that you're making, particularly if it could, at first glance, look like you're treating this homeowner differently than this one. So I think that addresses some of that question there.
I think it does. So there are many, many more questions. So I am going to cut it off with that answer, but I know there are a few that are very specific, and I do apologize for not being able to get to some of those. But
ask your lawyer.
Yeah, right. I would encourage reaching out to your attorney. Steve, I want to thank you for your time today. Really great presentation. A lot of great feedback coming in about the information. So I want to remind everybody that we will post a copy of this webinar on our board member section. So everything will be available. If you'd like to see this, the slides, it is available on the board member section of the CAMS MGT website. Next month's webinar will be on virtual meetings and some of the new law that was recently, I don't want to say passed, but it has been approved and sitting on the governor's desk. So we are all anxiously awaiting, but it's all about the modernization of business for associations. That's North Carolina specific, but we will be getting into South Carolina as well. So just best practices around virtual meetings, virtual voting, and everything else that's involved with that. So that will be on the third Thursday of October. So again, thank you everybody for attending, and we hope to see you next time. Steve, thank you again.
Thanks very much.